Hello, everybody. Hello, everyone. Sorry, and welcome to another exciting edition of the ESQ Practical Lawyers Academy free webinar series. We are glad you could join us here today. My name is Chidima Agu, and I'm a Research and Development Associate at ESQ Trainings Limited. Hope you all are having a nice time with the weather today. So, at ESQ Trainings Limited, our mission is to expand the frontiers of continuous professional learning with courses and training across various areas of practice. We have tagged this webinar series to launch our webinar series, as they are slated to hold at 1 p.m. during lunch breaks. They'll hold 3 times every week, Mondays, Wednesdays, and Fridays. However, in order to accommodate our Muslim participants, would hold Friday webinars by 11 a.m. and after every session, we would provide the resources available to everyone and to those who are interested. So you can now watch our webinars, the past and the ones we are to hold in the future, on our YouTube at my ESQ Legal. And when you are done watching, please kindly subscribe to our YouTube channel. Thank you so much. So on today's topic, we'll be discussing ethics in government contracting, and our panels would discuss on this particular topic extensively. On our panel, we have firstly we have Ms. Kumbi Sijuade Perez. She's a principal partner, Sijuade Awopetu and Associates Nigeria. Thank you, Ma, for joining us today. I don't know if you can hear me properly or you're on, but thank you for joining us today regardless. Secondly, we have Mr. Wogu David. He's a principal partner at Shield and Buckler Associates. He will join us shortly if he's yet to. So we also have Mr. Okezi Oka Ave. He's the company secretary and general counsel at QSL Gas and Power Limited, Nigeria. We are happy that you could join us here today. So 2 of our participants have raised their hands. So while we wait for our panel to join us, because Mr. David would be the first person to speak, like I said, and Mrs. Kumbi would speak secondly, and then Mr. Okezi. Okay, so yes, so Mr. David, thank you for joining us today. Hi, Mr. David. Hello, you're muted.
Can you hear me now?
Yes, I can hear you.
Can you hear me now? Oh, great. Good morning, a very good morning to you. And a pleasant morning to everybody who has tuned in and to my fellow panelists. I'm glad to be here this morning.
So, Mr. David, Mr. Okezi suggested that you would be the first to speak, and then Mrs. Kumbi, she's trying to join now, but her network is quite unstable. So she would speak after, when you're done your presentation, and then Mr. Okezi will be the last person to speak on the panel today. So I've done the introduction and the speakers that will be speaking today. So I think we would let you start and make your presentation first, and then when you're done, Ms. Kumbi would take over.
Very well. Thank you so much. I'm kind of re-echoing, I don't know. Hello?
Hi.
Okay.
Hello?
I'm kind of re-echoing, but I hope you can hear me very well.
Yes, I can hear you, and I'm sure everyone can too.
Okay, the theme of today's session is ethics in government contracting, and we are meant to run through, to begin it, I'm going to run through the understanding of the legal framework of government contracts, the ethics, the common ethics and compliance as much as I can, so as to allow my other colleagues who are also versed with this topic to continue. So firstly, we all know what contracts is. Contracts are promises or sets of promises made by two parties which are recognizable in law and recognizable and enforceable in law. And for the particular purpose of this, our session, that being said, is that a myriad of businesses in Nigeria and across the world for a myriad of businesses in Nigeria and across the world, landing contracts has been a much welcome and palatable source of income. So landing government contracts is usually a palatable source of income for individuals, companies, and investors. But the key issue is always compliance. Compliance and competence for me. Compliance and competence. How competent is a company or a contractor seeking this government contracts in the field and the area which is seeking this contract, and how much of compliance knowledge does he have in entering into these contracts, right? So given the societal expectation of people on the government and time factor associated with tenure of each government, a proposed contractor is expected to be a top professional and have in-depth competence in the area which is seeking to contract. So therefore, whilst entering into a government contract, whether with the local, state, or the federal government, a contractor must first and foremost ensure that its house is in order regarding areas of competence and his capabilities. And I will run us through, because of time, I'll run us through what I term the pillars of ethics that I believe that are core for every contractor, both for the contractor and for the government official. So the contracting ethics I've itemized are understanding your company's areas of competence and capability, then compliance with laid down procedures, authorities, and statutory rules and that of the institutional rules of the government agency where you are seeking the contract. Then you also have to be professional whilst maintaining good relationship with the government agency. A contractor is also to ensure that he doesn't miss a deadline. It's always important that a contract it's time bound, could be time bound. A contract could be specific around time. So missing a deadline could lead to breach with its attendant consequences. So the other point is a contractor must provide a dedicated client relationship manager for a government project. Yeah. And the last but not the least, which will form the bulk of my discussion, will be to desist from kickbacks. Kickbacks is actually is almost like a fun way of saying bribery and corruption, right? So having said that, I will quickly jump to the key areas, the key legal frameworks. The key legal frameworks around government contracting. I think the Nigerian legal system has been very exhaustive about its position on government contracting from inception to breach and punishments thereof, right? So for the legal framework for these government contracts, given the intricacies and complexities of government contracting, various legislations have been promulgated to regulate government contracting. The key amongst these regulations are as follows, and they are one. Are you with me? Hello, are we all together? Please, I think I'm running too fast. Am I running too fast?
No, you're not.
Oh, very well, very well, very well. So the key statutory provisions around the legal framework of government contracting are as follows: the Public Procurement Act of 2007, that's the PPA, the Bureau of Public Procurement, the Bureau of Public Procurement as well, which is also an enactment, a subsidiary legislation from the Public Procurement Act, that's the PPA. The National Council on Public Procurement, that's the council. Public procurement regulations for consultant services. The other one is the Public Procurement Regulations for Goods and Works. That's it was made in 2007, PPRGW. Then the Execution Order number 1 of 2017 on the promotion of transparency and efficiency. Then again, we have the Fiscal Responsibility Act of 2010. Also, we have the advance fee fraud. Now, these are now the statutory provisions and regulations that will deal with punishments where there are breach with contracting regulations and law with both the contractors and public officers. So there you have the Advance Fee Fraud and Other Offenses Related Act 2006, the Independent Corrupt Practice and Other Related Offenses Act of 2000, the Code of Conduct for Public Officers as contained in the 1999 Constitution, the 5th schedule to the 1999 Constitution of the Federal Republic of Nigeria, the Public Complaints Commission, and the Freedom of Information Act. We also have the Criminal Code. Remember, we are speaking to the punishment sections now, the codings, the statutory provisions that has punishment sections for offenders of possible government contracts, right? Or public officers who do not work in line with the provisions of the regulations around public contracting. So the Criminal Code, which is the provision for criminal laws for the southern states, then the Penal Code, which is the provision for that of the northern states, both of 2004. We also have contemporarily, we also have the international conventions. That's the United Nations International Convention Against Corruption. It was signed and ratified by Nigeria in December 9, 2003, and ratified on the 14th of December 2004. We also have the last but not the least is the African Union Anti-Corruption Convention, signed in 12th of December 2003 and ratified on the 26th of September 2006. So these rules, particularly, I will just mention the provision of the PPA regarding this government contract. The PPA is a regulation that covers all procurements of goods, works, and services, right, undertaken by the government and all procurement entities, and all entities outside the foregoing description, all entities outside the description that derives its funds from the 35% of the appropriated or proposed to be appropriated funds of the Consolidated Revenue Fund. So, I mean, the PPA, the BPA are the regulatory frameworks around government contracting. They are in charge of the biddings, publications from inception until the end, while we now have the other punishment sections which I have mentioned. I don't know if I still have time within my 15 minutes. Hello? Am I still in order? Do I continue within my 15 minutes? Hello?
Yes, you can. Yes,
okay,
you can.
Okay. So before I leave my other colleagues, because it's a topic that we have panelists who are to deal with them serially, I would quickly mention that our legislation, the legal framework around this public procurement and government contracting are quite robust. For me, what the issue is how How efficient? How do we follow these laws? How do we ensure that these laws are not just these legislations are not just documentations that are just existing? How do we ensure that these enactments are made enforceable against culprits and offenders? That is the issue. There are a myriad of laws, there are a myriad of punishment section. Even the system has the backing of the courts, right? In enforcing and enforcement of the laws around government contracting. What is key for us, and what is key for us is a calling on the system, on the government, to ensure prosecution, and also to ensure that their policies are made, and these policies that are made, which I have also mentioned that already we have robust policies existing around the system, that the system, the MDAs are sensitized, are sensitized and duly informed, and perhaps more seminars are to be held around these provisions of the laws to ensure compliance. So on this note, I will be leaving the other panelists to take over from where I have stopped. I'll be open to questions and answer when the time arises. Thank you.
Okay, thank you, Mr. David. Are you Mr. Okezi? Okay, sorry, not Mr. Okezi. Mr. Okezi said he was going to speak last. So, Mrs. Kumbi, I think you have to make your presentation now. You're muted, ma. Okay.
Good morning, everybody. Good morning. Good morning. Can you hear me now? Good morning. Can you hear me?
Yes, I can hear you, Mr. Kumbi.
Okay. Thank you very much. I count it a privilege to be invited today to speak on the topic ethics in government contracts. I have my slide here. I'd like to share my slides. One second, please. I think I'll make the slide available shortly after the presentation. Okay, so ethics in government contracts. The World Bank country procurement. I'm sorry, once again, let me just get the right. Okay. Okay, so public procurement constitutes a larger proportion of total annual government expenditure in developed nations, and much more in developing societies where governments are expected to use the public procurement system as a tool for socio-economic transformation. It is said that the greatest amount of financial corruption resides in national procurement systems. Generally, it is said that as much as 20 to 60% of public spending on procurement is lost due to leakages and malpractices in developing countries, and Nigeria is not an exception. In Nigeria, in spite of the huge government budget over the years for the provision of goods, work, services, and services, there has been a discernibly wide expectation gap. The World Bank procurement assessment survey that was conducted sometime in 1999 actually reveals that out of every 1 naira that is being spent by the Nigerian, every 1 naira goes into underhand practices. And it was estimated that an average of about $10 billion was being lost annually due to weak public procurement procedures, which encourage corrupt practices such as fraudulent practices in the award and execution of public contracts through inflation of contract costs, lack of procurement plans, poor project prioritization, poor budgeting processes, lack of competition and value for money, and other kinds of manipulation of the procurement and contracts award processes. So as a result, the Budget Monitoring and Price Intelligence Unit was established sometime in 2001 as a unit under the presidency to look into the issue of deficit in the government expenditure. So prior to that, what was happening was that we did not really have standardized procurement procedure, procurement guidelines. We didn't have a particular law. What we had was that different MTAs, different parastatals had their own individual procurement laws, which allowed for corruption, and most of them were not in line with international best practices. So it was important for Nigeria, and especially because of the pressure that was being put on the country and other developing countries by international bodies like the IMF and the World Bank. The pressure was that they had to do and we had to reform our procurement process, because that was where leakages were coming from. Those were the things that were funding and corruption. So as a result of the BMPIU, which was called due process, that was actually established to address the issue, but there was a limit to what the BMPIU could do, because they actually lacked the requisite framework to work as effectively as it should. So sometime in 2003, the PPP bill was sponsored, and eventually in 2007, it was actually enacted into law. And since that, it is the BPP Act that has actually been governing procurement in Nigeria. So today, I'll be talking about ethics in government procurement, the legal framework for public procurement in Nigeria, issues of ethics emanating therefrom, ethical violations of procurement of offences, investigation of offences, prosecution, and punishment. So if you talk about ethics generally are the accepted moral standards of doing things within an organizational setting. And then procurement, on the other hand, has to do, especially government procurement has to do with the modality with which government purchases services, goods, and works with contractors, suppliers, and consultants alike, whether at the national, international, or the local level. Public procurement, which is also government contracting, is actually a key determinant of the overall development condition of any country. If you want to know if a country is doing well, you have to look at the procurement laws. Most developing countries don't have good procurement laws. So what happens is that if an X amount is attributed to expenditure to whatever project, they find out that what is going to be released eventually for the execution of the project is minimal, and often at times it's not enough you want to execute the project. So you find out that it impacts negatively on the economy of such country, like ours, like our situation in Nigeria. We have abandoned, say prior to the administration of President Buhari, we had a lot of abandoned projects everywhere. The citizens are frustrated. So it's been difficult for individuals that are not even civil servants to make ends meet. Even civil servants, it's difficult because whatever salary you are earning, you use it to pay for utilities that government should pay for ordinarily. So government procurement is so important, it's so pivotal to the success of any economy. And then if we're talking about ethics in government contract, it's difficult for one more to actually make a recourse to the Public Procurement Act 2007, like I said. If you look at that 2007 Act, it is actually, in my own opinion, and the case it just said, it's a very detailed and robust act. States precisely at what government or procuring entities and contractors, leaders, what they should do per time. It talks about, it states precisely what should be done at every stage of procurement, from advertisement for tenders to selection of preferred bidder to execution of contract. And you find out that if you look at the sections, the various sections, you find out that some of these ethical principles, there are lots of ethical principles that run across the Public Procurement Act. But most particularly, if you look at the objectives of the Act, it says that the Act, well, through the BPE, it's to harmonize existing policies on procurement, ensure probity, accountability, and transparency, establish pricing standards and benchmarks, ensure the application of fair, competitive, transparent marketing standards and practices for all procurement and disposal of public assets and services. And then, without wasting too much of our time, what I'm just saying in essence is that certain ethical issues run across the BPP Act, and those are the things I want us to look into, because those are issues, those are ethical issues that we evaluated from time to time, despite the robust nature of the Act. Well, I mentioned here that some of the ethical principles that we'll be looking at are honesty, probity, accountability, integrity, impartiality and fairness, transparency, efficiency, reliability, loyalty and respect for rules and regulations, confidentiality, avoidance of appearance of impropriety, due diligence. I wouldn't say this is exhaustive anyway, but those are some of the ethical issues that I could get from the BPP Act. Then I also made reference to some of some sections there. So section 757.2 of the BPP Act, it says that all conduct of all persons involved with public procurement, whether as official of the bureau, the procuring entity, supplier, contractor, or service provider, shall at all times be governed by principles of honesty, accountability, transparency, fairness, and equity. The same goes for 57, section 57 and 8, which also encourages all public officers involved in public procurement to, in their relationship with persons, real or corporate, who seek government commerce, that is bidders, suppliers, contractors, or service providers, that they have to develop traits of transparent, they need to be transparent, they need to be honest and conduct their relationships in a professional way, without wanting to bore you with a lot of too many of these sections. I would also like to make reference to, okay, like if you look at section 16 that talks about the qualification of contractors and bidders, it states, for instance, what the bidder, the criteria, and that is it is actually open, everybody knows, and that's one of the good things. That's one of the good things about having the BPP Act. Everybody knows what the law is and what they need to do per time. So, for instance, anybody that is bidding in Nigeria, they are expected to have the professional and technical qualification to carry out particular procurement. They are supposed to have the demonstrate financial capability. They are supposed to show that they have equipment and other relevant infrastructure to carry out the whatever project they are bidding for. That they should be expected to have adequate personnel to perform the obligations of the procurement contract. They're supposed to have better capacity. They are not supposed to be in receivership, insolvency, or bankruptcy. They are not supposed to be in any bankruptcy proceedings whatsoever. And then, of course, they should fulfill their obligations to pay taxes, pensions, and social security contributions. Those are some of the requirements. And then they are not supposed. They're supposed to also post an affidavit disclosing whether or not any officer of the relevant committees of the procurement entity of the bureau is a former or present director, just to show that there is no conflict of interest. And then I also make reference to the section that talks about disqualification of contractors for non-compliance, and that is the good thing about having the BPP and BPP Act, unlike before where people were given contract, they awarded contracts based on their relationship with various heads of MDAs, politicians, or even the contact at the presidency. So the good be disqualified if they do not meet up with certain criteria that I mentioned earlier, or where it has been found that they are trying to bribe any official of the procuring entity. It's also detailed, if we were to go through all the issues of ethics going in that act, we will not, I won't be able to make my point as early as I want to. So I would want to go through, or move to ethical violations in government contracting. I think that is relevant at this point because we talk about the various ethical issues that are promoted by the Act. We also need to talk about the ethical violations in government contract. So I listed some that are very popular that we all know. We have the issue of bribery, we have lobbying, we have collusion between stakeholders, heads of ministries and parastatals, sometimes the contractors, other times with politicians who have an interest or vested interest in certain projects that are being about to be awarded. We have undue and unwarranted contract extension due to contractors' inability to complete a project, either as a result of mismanagement of funds or because there has been a large portion of it has been used to bribe the stakeholders. Sometimes, and then of course we have the issue of shoddy job. The job that is delivered is quite different from what was actually projected for. We have lack of professional and technical qualification. A lot of people bidding, a lot of contractors bidding for works are not actually they are not qualified for the jobs they actually bid for. Sometimes they don't even have companies, they don't have the required technical know-how, they don't even have tax clearance certificates, but then they go and shop for a company, an existing company that they can use, even when, especially when the company is not interested in such projects. And of course, those kind of contractors, they are given the opportunity to, in some cases, they're just awarded the contract. And then when it comes to execution, getting professionals to actually execute, it becomes a problem. We have a legal agreement between tenderers also resulting in similarly competitive bids. In some cases where there's direct bidding, you find out that there's really nothing like the bid because the other companies that are brought in are not actually there to actually bid per se, but they are there to be a distraction because if they're working to a particular threshold, they can get tenderers that are not really serious or intending tenderers. They will just bring 3 or 4 people to bid higher, way higher than the threshold. Some people to bid lower than the threshold, so that a particular chosen contractor that has been earmarked for the award is actually given. We have hidden fees and commissions, which are usually given to protect the interest of politicians and then, of course, sometimes the procuring entities, or a lot of times the procuring entities. We have a lack of experience and capacity, which is also related to the lack of the technical know-how that I mentioned earlier. We have a conflict of interest, interest of the public, of the stakeholders, politicians, and all. It's usually very different from that of the public. So if the X amount has been awarded to a particular contract, you find out that the people sponsoring the contract themselves are not actually interested in the act execution. They're interested in what quota that comes into the pocket. So these are some of the ethical issues that we have in government contracts in Nigeria. We have abandonment of projects, that I already mentioned. We have undue regulation waiver due to bribery, and of course, we have rigging. So those are the ones that I highlighted. But again, the BPPA also mentioned did not leave all these some of these issues as mere ethical issues. Well, actually, the BPP Act, excuse me, the BPP Act actually criminalized some of these offenses. If you look at Section 58.4, it talks about collusion. Collusion says that entering or attempting to enter into a collusive agreement without whether enforceable or not with a supplier, contractor, or consultant where the prices quoted in their respective tenders, proposals, or quotations are or would be higher than what would have been the case as there not be collusion between the persons concerned. This is a criminal offense, but you find out that it is the norm in procurement generally now. Every somebody is colluding with the other person, otherwise they believe that they are not going to get the contract. And it's almost as if that's just the way it is done. But under the act, it is an offense, and I believe that a lot of people should avert their minds to that. Conducting or attempting to conduct procurement fraud by means of fraudulent and corrupt acts, unlawful influence, and this has to do with bribery. And then again, directly or indirectly, or attempting to influence in any manner the procurement process to obtain an unfair advantage in the award of a procurement contract. That is also a criminal offense. Splitting of tenders to enable the evasion of monetary thresholds. So where some entities are doing direct bidding, and the threshold is probably like maybe the threshold is 10 million, and then they need to award a project of 25 million, which you don't have the leeway or the permission to actually award. If it be above the threshold of that particular ministry, we find that they want to split it into different tenders just to make sure that it's within the monetary thresholds. This is also a procurement offense. Bid rigging is a procurement offense. Altering any procurement document with intent to influence the outcome of the tender proceeding is also an offense under the Act. There are punishments for violation of the BPP Act. There are punishments, just that a lot of times we don't see, the members of the public, we don't see that aspect of justice being done. But then I wouldn't say that it is not done at all, but it is not in our faces. So Section 58.1 says that any natural person that is found guilty of an offense under the Act is going to be liable to a term of 5 years, nothing less than 5 calendar years, but not exceeding 10 calendar years, without an option of fine. 58.5 talks about if the person, an officer of the bureau or a procuring entity, that is any civil servant, if any civil servant is found colluding or involved in any malpractices or any ethical issues, any ethical issue in procurement process, they can be guilty. If found guilty, will be sentenced to a term of imprisonment not less than 5 calendar years, in addition to a summary dismissal from government service. Then, of course, if it's a company that contravenes, the punishment is also a debarment from all public procurement for nothing less than 5 calendar years. That means such companies will not be able to bid for any public work, so any public contract for a period of 5 years, and then it's going to pay, the company is going to need to pay a fine of 25% of the value of the procurement issue. Where the legal person, that means the company, is convicted, all the directors too are supposed to be convicted alongside, at least to a period of 3 years, nothing less than 3 years, but not exceeding 5 calendar years. So that's a provision of the Act on punishment of offenders. So when you look at the BPP Act, and then it's not as if these violations of these ethical violations that we have in procurement, it's not as if they are not actionable. Like I said, the problem is it's not that we don't have good law. As far as I'm concerned, I think this law is good, but probably the government or the relevant stakeholders actually lack the real power to enforce it as they should. Where anybody is found guilty, they have the right for the Act says that it is the federal high court that should have jurisdiction, and the prosecution should be in the name of the Federal Republic of Nigeria by the Attorney General of the Federation. It is the Federal Attorney General of the Federation that can actually prosecute or that can delegate someone to prosecute persons on behalf of the government. So that is basically the provision or the situation, the legal framework I am affecting or governing procurement in Nigeria, as well as the issue of ethics and ethics violation. Here, it's as if we have highlighted problems, we have all highlighted problems, and I've also said that, well, we have good laws, but then BPP has been able to save Nigeria a lot of money, because, like I said, before the Act was passed into law, Nigeria was losing about 10 The PPP from the records, I think between 2013, from 2007 to 2013 fiscal year, they said they were able to save about 520 billion naira. Well, that is a lot better from where they are coming from, but it's not. That is not what we are looking at, because we still know the high level of corruption we have in our country. So I would say that the solution we have, if there is any solution at all, is that our leaders must have the power to fight corruption. Because if these issues of malpractices are coming from up there, it's difficult for anybody to actually do anything. Where you have National Assembly members performing oversight functions on some ministries, having interest in projects that are being awarded there, then it's difficult for anybody to go after them per se. I know that the PPP has a whistleblower policy, and I just hope that it is. I think it's better if it can be strengthened, and then people within the organization can always blow whistle against any malpractice or violation of procurement that may be going on. I believe also that the BPP and procuring entities should also be fair and unbiased in the process of selecting the lowest responsive bid in line with the prior approved threshold. I'm also suggesting that the BPP and procuring entities should act independently and not down to the needs and purposes of politicians performing oversight functions over the MDAs. They should also properly train the officers on the ethics of procurement and the need for them to embrace and imbibe the tenets of the code of conduct. Offenders of that must be promptly prosecuted and or dismissed from service so as to act as a deterrent to others. And then aggrieved contractors must also seek an administrative review that is provided for by the BPP. They should take steps and not be discouraged, and do not take the loss as finality. If there's injustice that is being done in the process of procurement, they should petition. They should make their complaints known to the procuring entity as well as BPP and seek justice. This is the only way we can make BPP and the procuring entities accountable to the law. So that's my contribution. That's my contribution in this discussion for this meeting. Thank you very much.
Thank you, Mrs. Kumbi, for the extensive presentation. Mr. Okezi, so now you really have to say something.
In my mind, I'm asking myself, how do I follow that? Because you have covered A to Z.
Exactly.
You've done a really, really great job.
Yes, you have.
Extensive research. Good job. And David too. Good job as well. My name is Ukezi Okabai. I work with QSL Gas and Power. I'm General Counsel, Company Secretary. I'm wondering, how do I follow up Kumbi? It's going to be difficult, but I'll do my best. I guess what I can speak to is my experience, because before I joined QSL, can you hear me well?
Yes, we can.
Okay. Before I joined QSL, I was with Nigerian Gas Company and Nigerian Gas Marketing Company. These are wholly owned subsidiaries of NNPC. And during my time with them, I believe that I've gathered some experience, some insights into their tendering process, because they have an extensive tendering process, which for obvious reasons has to be as transparent as possible. Before I proceed, let me just, because I have some slides, I've been trying to see how I can share, but I'm having network issues as well. Okay, don't let me run over what Kumbi has said. Let me just jump straight into what I want to say. So I have a case study, which is basically, can you hear me well?
Yes,
okay,
we can.
Okay, I have a case study, which is the NGC tendering process. First step is understanding what you are contracting for, why you need your contractors on board to carry out particular works for you. NGC, just to provide some clarity, is the entity under NNPC that has the trunk lines that move gas in Nigeria. The major trunk lines, they own them. There's OP3, and also there's the ELPS. They own those lines. So obviously, they are used every day. There's wear and tear on the lines. Every once in a while, you have to fix. And for you to fix, you have to get in your contractors to come in and bid to carry out those works for you. So the process is, so the question is, how do you bring them on board? First step is, there is a committee, but there's a board called the Management Tender Board in NGC, MTB for short. And this board, they are responsible for everything that has to do with receiving tenders, evaluating the tenders, approving the tenders, and directing the legal office to issue out contracts. The MTB is made up of chairman, who is the MD of NGC. Each general manager is also a member of MTB, then there's a company secretary. On MTB, the supply chain manager is the custodian of everything that has to do with the tendering process. So it's the supply chain manager that will advise the board on every public procurement policies that they must follow, that the contractor must abide by in whatever criteria they have. When you have your tenders, when they come in on board, the user department, which is more or less the department in NGC that actually needs the work that should be done, will seek MTB's approval for a contracting strategy. So the contracting strategy is, you could say, okay, we would do an open bid or something closed. Open bid is, the training is open to everyone, and the closed bid is more or less you are handpicking contractors that have worked for NGC, that over the years have shown their competence, over the years they have shown their expertise. So you will shortlist from that list, and most times you have that short, that small bid window when the works are absolutely urgent. So you have to fix part of your pipelines, or you have some other works to carry out as quickly as possible. You don't really have time for a long tender process. So you more or less shortlist contractors that you have worked with and you can verify their competence. So once MTB approves that contracting strategy, the user department will then throw out the bids to contractors that they have. They are contacting the contractors, or they can put it on a public platform for contractors to come in and bid. When contractors come in to bid, the user department has to go back to the tender board to tell them that these are the contractors that have bidded. We have carried out evaluation of their bids. There are different criteria for evaluating such bids. They are looking at their technical competence. They are looking at community engagement, because most of the pipelines that NGC has are very much within the Niger Delta region. So you have to look out after the community. You have to maintain good community relationships with them. So you're looking at contractors who over the years have shown good community management in your criteria as well. You're also looking at their corporate structure, you're looking at their taxes, you're looking at their finances. You are trying to ensure that whatever quotes we provide, whatever bills they have given, matches your in-house estimates. And even looking at the in-house estimates, the user department, they are very, very much aware of the fact that whatever quote has been provided by such a contractor must be within a bandwidth that has been set by NNPC. So typically, it should not overshoot your in-house estimate by, let's say, more than 10%, 50%. Once in a while, NNPC would advise the management tender board to adjust whatever bandwidth or parameters they have for coming up with in-house estimates, and whatever margin can be given to contractors coming to bid. For example, NGC wants to fix a part of their pipeline. From their in-house estimate, it costs, let's say, 50 million naira to carry out these works. The contractor comes and is bidding 55 million naira. Most likely, he's within whatever bandwidth he provided. And it's also good for contractors not to underbid, because when you underbid, you are more or less showing your incompetence. You're more or less showing that you haven't carried out proper market research. As I said, you have a job of 50 million, which is more or less the in-house estimate. I'm a contractor, I come and I'm bidding 30 million. I would expect any serious tender board to throw out your bid, because it shows that you haven't done your market research. If you have done your market research, you will know that you should be looking at the range of, let's say, 45 million, 50 million, 55 million. If you are coming with 30 million bid, it shows that you haven't really done your market research. You can't say that because you want to win a particular bid, you shoot yourself, because if they give you that contract, you then come back to meet NGC asking for a price variation. And most agreements that NGC has, they do not allow price variation. So right from the get-go, you have landed on the price. So in addition to some of the things that the committee would evaluate is your HSC plans. They are trying to see what plans the contractor has when it comes to do with protecting the environment and maintaining the integrity of the environment. So these are some of the things that they will look at. Once the committee, they are done with their evaluation, most times they score them, there'll be a scorecard to determine who is first, who is second, who is third, who is fourth. They will present the scorecards. There would most times be a cutoff mark. Typically in NGC, cutoff mark is about 60%. So anybody who scores above 60% goes through the evaluation process. And typically in projects like this, in processes like this, you start with your technical evaluation before you then jump to the commercial evaluation. So you need to be sure that you actually have the technical competence to carry out the works. And once you have done that, you then look, okay, how much have you actually, how much do you think you can carry out this works for? And then there's more or less price negotiation on that with the contractors. So once you have that technical bid, give your recommendations to the tender board, they look at it. And in all cases, not most cases, in all cases, the MTB would also carry out a second level evaluation. So when they sit down to have a meeting and they are going over the report, more or less the evaluation report from the committee, they would ask questions. Whoever is defending that report would have to stand and answer questions. Why have you chosen these guys? Why do you think this guy is competent enough? And they will defend. Most times, their criteria have already been set, so it's easy to defend such a report. So once there is that conviction that yes, these contractors, let's say they are fine number, they can actually carry out the works, then they would sign off on it, and then they move on to commercial bids. So they open their commercial bids, they look at them, and that's when you narrow it down. Who is giving us the best price? Whose price is most reasonable? Who is competent, can do the work, and also has a very good price, has put a good price. So once you have all of that sorted out, typically you arrive at your preferred bidder. So you are so you sign off on it, the MTB board will sign off on it that this is our preferred bidder for this. However, there is a final stage before they even issue a letter of award to the contractor. They would have to seek the GMD approval. GMD are from NMPC, they have to seek his approval. So there's a GMD sign-off that will come from the GMD's office, and that sign-off more or less ratifies the approval process that's been done by the MTB. Once MTB gets that GMD sign-off, the next step is to contact the legal department for them to issue contracts. And obviously, it's key because we as lawyers, we should realize that it is key for lawyers while drafting their agreements to have at their hand a copy of the approval that comes from whichever board is in charge of approving such bids. Because your contract must align with whatever has been approved. You can't put certain clauses that basically have no business being there. They were not in the approval documents. So it's good for lawyers to have that at the back of their minds. Typically, in contracts that NGC or NGMC would sign with contractors or any other third party, it's always advisable. While I was there, it was always ensured that we had a robust business conduct and ethics provisions in the contract. Every contract, whether it's a contract where one of our subsidiaries, NGMC, is selling gas, or NGC itself is transporting gas. We always have to put it there. We need that comfort. We need that assurance that we have abided by all compliance laws, statutory regulations that have to do with anything that has to do with anti-bribery, anti-robbery, unethical conduct in Nigeria. They are also asserting that the contractor will comply with all industry standards in his works, all industry policies, whether it's HSC, whether it's a local content issue. The contractor needs to sign up that he's going to be compliant with that. And also in that provision, you are being very, very expressive when you are stating that any sign of money exchanging hands, any take back, any gift, any bribery is obviously not encouraged in any way, shape, or form, especially when such is going to a government official. And on the other hand, again, you're also looking at the fact that any kind of government official trying to benefit off the relationship with the third party, for example, the government official is trying to have a side business or side agreement with the third party. It's very much frowned upon. So you have all that. And then also in addition to that, you are having your whistleblowing provisions in your agreements. It's always good to have good corporate governance practices, whether you are a private company or you're a government entity. As long as you have an image to uphold, it's always good to abide by good corporate governance practices. And there's something called a sovereign immunity, which NGMC has in some of their agreements, just to provide some clarity to that. Sovereign immunity basically states that the government will not. So if in the case where a government official has been found to do certain things that that connotes, or let's say the government company itself has been found to do certain things that connotes corruption, bribery, or anything like that, then they will not be immune from being sued by the third party, private company. You understand? Because most likely, if that happens in my contract, then there's a question about how I even got the contract. If I'm a contractor, and then it's found that there's some funny rumor going up and down that my company was involved in bribing a Nigerian entity on certain things. It's bad for my image. It's bad for my image. I want a scenario where I can sue to protect my image, and the government company will not say, we're a government company, we're a government you can't sue or sue. It's advisable. It's advisable. So most of what I've spoken about now, it's what I'm practicing as of today, because as I said, I'm now the TSL, that's marketing and distribution. And we have some relationships with NGC, some relationships with NGMC, and the contracts are still the same. I know that the process is still very, very much the same. I would use this platform to say NGC and NGMC, because I know that they are very, very compliant when it comes to having good ethics in their contracting with third parties, be it vendors, contractors, or even customers that need their services. I hope I've been able to provide some kind of contribution. Once again, thank you for this opportunity.
Thank you, Mr. Okezi. Thank you. You did very well. Thank you so much. So there's some questions. I think 3 questions for our 3 panelists. So firstly, we have one for Mr. David. So the person says, if there is a breach on the side of the government, the next option is to bring an action against the government in court. But we know how slow the administration of justice is in Nigeria. So how can the company be protected in respect to all the resources wasted?
Well, most of the time, thank you very much, first of all, for that question. Most of the time, people, litigants sit at home and they just say that this system is not working. We have created that culture of not believing in the system. I'm a practicing lawyer. There are some judges who are very, very, very active, who hear matters very expeditiously. I believe Okezi and Kumbi will attest to that, in fairness to those kind of judges. So we have to remove that mentality first. We have to emancipate ourselves from the mentality of assuming or presuming that the court systems are not fast and will not aid such a situation. Unfortunately, the Johnson strike does not support this, but while the going is on, because some courts are doing their best, some courts are doing their best. So prosecuting is always an option. The counsel whom you will engage is also a very big factor. How he will track his matter, how he will follow up the matter diligently. It's a cause for concern of a litigant. So getting the right counsel who is diligent, prudent to prosecute the matter diligently, is a key factor for a litigant. Then, like Okezi has mentioned extensively on contracts, how you draft your contract will also help shaping some of these clauses and breaches that may lead to litigation. So that is my suggestion. So the courtroom, it's an open place for you, and the court system of Nigeria is not as bad as it's painted. Thank you.
Thank you, Mr. David. Second one goes to the company secretary and general counsel in the house, Mr. Okezi. Okay, so it says government contracting in Nigeria is a big deal and can be very beneficial to a company. But what happens when there is a conflict of interest in execution of the government contract and the company's interest? Should the contract be rejected, or can there be a remedy to this?
Well, if there's a conflict of interest, it's always best to err on the side of caution and let go of that that kind of transaction. When you say conflict of interest, are you saying they're interested parties? So a government official has some kind of relationship with the company. If first and foremost, that's a big no-no. In certain government organizations, in certain government entities, if not all of them, they have code of conduct. And one of the things it states clearly is that government officials, government staff are not supposed to have interest in other companies, in companies that are more or less competing with that government entity. So it's a big no-no. If there's any kind of conflict of interest, my advice is not to even go on about it, because there are times when you would even try and continue with that kind of relationship with the company, with the government company, and the government company can actually blacklist that that company from bidding on any kind of work. It has happened in NGC a couple of years ago. A company was trying to take advantage of something, and NGC obviously had to maintain their standard, and they had to blacklist such a company. It had to do with conflict of interest around that. I hope that answers the question.
Okay, thank you, Mr. Okezi. Mr. David, do you have something to say?
Yes, please. I have something to add to that question that was put across to me.
Okay.
The arbitration clause would also be of help to a prospective litigant. The arbitration clause. There are clauses which can take matters not to court, but to settle these matters outside the court without going to the court system, which are there. These systems are known to be quicker. Yeah. So your arbitration clause should be, you have to put arbitration clause in that contract agreement with the government. That will help you in cases where the court, where you believe that the court may not give you justice as quick as you would like. You can explore alternative dispute resolutions and the provisions of arbitration clauses, which are known to be quicker, faster, and more expedient for contracts such as that with government. Also, that is what I wanted to add.
Sorry. Also, in addition, it's good to have your contracts expert determination. where you have experts that will come in, and if there's a dispute or there's an issue between the parties, you have an expert who has experience in whatever industry, whatever field. He will be able to step in, and then based on his own experience, look at the two sides, probably hear from them, and then advise them. This comes in when you're still trying to maintain your relationship with government company, and also carry out some of the activities, or more or less carry out some of your obligations while you are having that back and forth with government companies. So yeah, in addition to arbitration, it's also good to have expert determination.
Okay, thank you. So the strict rule of sending of gifts to government worker as a sign of bribe or gratitude. So what happens if there is a personal relationship between the person awarding the contract and the individual getting the contract?
Okay. First about that question, it's important to establish that that gift or that relationship does not in any way influence the decision that will be made by the government official in your favor. My brother could be in CBN. My company might want to do one of the things with CBN. I might then bid for that. My brother, who is probably in an evaluation committee, has to show that our relationship has not affected his decision making in evaluating my bid pack. So for me, that's key.
The question was for Mrs. Kumbi.
Oh, sorry.
You're muted.
I said, if I must answer that question sincerely, the answer the person asking the question will not be a very favorable one. The issue is that, okay, if we're to follow the law as it is, if you have a relative or you are close to somebody and then you are sitting over anything affecting that person, there's already a conflict of interest. So you should not preside over it at all. You should remove yourself. You should declare that there is a conflict of interest. I am connected to this person in this way or manner. So it shouldn't be. But then again, if you're giving gifts and then, well, I think that answers it. That just answers it. If you're giving, sure, you shouldn't be giving your brother a gift. If your brother is in a parastatal where he's sitting over maybe a bid or maybe an award, or you are bidding for a contract under him, then there's already a conflict of interest. It is not given in good faith. It will not be deemed as being given in good faith. It's not Christmas. It's not as if you're going reserving his birthday. Once it's your brother, it should actually withdraw himself from that committee sitting over such a program.
Okay, thank you, Ma. Thank you. So with this, we've come to the end of our webinar today. Thank you to our panelists for this very intensive session, irrespective of the weather. And I'm sure most people just want to be in their beds or just relaxing, but you still showed up today at the webinar. Thank you so much. Thank you, Mr. David, for joining us today. Thank you, Mrs. Kumbi. Thank you, Mr. Okezi. Yes, and thank you also to our attendees for joining us today. Thank you to our sponsors, Alex, GLS and Co, Great Chapel, Bloomfield Law Practice, and Advocate Law Practice for making this webinar possible today. Our next webinar will be on Monday by 1 p.m. and we're going to be talking about depression as an occupational hazard for lawyers. So please tune in by 1 with the webinar.
Sorry, I didn't hear that.
The topic would be depression, an occupational hazard amongst lawyers.
Oppression.
Yes, depression.
Depression, okay.
Yes, okay. Yes. A lot of young lawyers are depressed. So we want to handle handle that topic intensively on Monday.
Paid into depression.
So join us on Monday.
Terrible.
And like I said earlier, please subscribe to our YouTube channel to watch our past webinars and more webinars to come at My ESQ Legal. Thank you everyone for joining us today.
Thank you very much, Chidima.
Thank you very much. Thanks, David. Thanks, Kumbi.
Thank you, Chidima. Thanks, Kumbi.